My name is Chuck Dick. I have the privilege of being a co-chair of the programming committee for California arbitration. And one of the special features of my job is to introduce you to some interesting folks that I've come to know within the arbitration world in California. And today we've got a really special guest, a person who's steeped in alternative dispute resolution with a wonderful story to tell. And I'm delighted to welcome you, Aaron Gothelf. He is the regional vice president of the commercial division, I should say, of the American Arbitration Association's operations in California. And Mr. Vice President Aaron Gothelf, welcome to California Conversations.
Thank you so much, Chuck. I just want to say, I listened to a couple of your recordings and they're excellent. I feel like I've learned a lot about people that I thought I knew about a lot about. I didn't know that Katie Connolly, for example, was a fifth generation California cattle rancher, and she was still essentially running a cattle ranch while working full time at Norton Rose. You really learn a lot of interesting stuff like that about people watching these videos, and I don't know if I can compete with Katie because I'm not a fifth generation California cattle rancher, but it's certainly interesting to know.
We don't expect everybody to be wearing Levi's and cowboy boots when they show up for this, but she was certainly an interesting example. What we're trying to do here with this California Conversations program is to let the world know some of the interesting people that are populating our profession here in this neck of the woods. And I'm, as I said, delighted to have you come on board today to tell us a little bit about yourself. And what better place to start than tell us how you got to where you are today?
This is a special year for me, 2026, because this actually marks 10 years in the California ADR industry for me. 3 years, roughly 3 years with Judicate West, and then coming up on 7 with AAA. And 10 years might not seem like a long period of time, but I guess I'm still young enough where 10 years is a long period to me. And professionally, a lot of stuff's gone on in the last 10 years. And then personally, getting married, starting a family, all that kind of stuff in the last 10 years. So on the personal side, it's been a busy 10 years. So 2026 is a special year. It's a special year also for the AAA. I've been in the industry for 10 years. AAA has been in the industry for 100 years. So in 2026, we'll celebrate our 100th anniversary here at AAA.
You are a man of California roots. So tell us a little bit about that part of your background and how it led you into the ADR field.
I'm a native Bay Area person. I was born in San Francisco, Kaiser Hospital, right there on Gary Street, still there, and spent the next roughly 18 years of my life in Marin County across the bridge in a little town called Mill Valley, if people are familiar with Marin, right by Sausalito. My father still lives in the same house in Mill Valley that I grew up in, and despite kind of living all around the country and taking breaks for education and working in different places, I eventually made my way back to Mill Valley. So I live in Mill Valley right now. After high school, I didn't really know what I wanted to do. I just knew that most people after high school go to college. I went to USC down in Southern California. I was very fortunate to be accepted to the USC School of Film and Television, so I have a film degree from USC. Did not necessarily know what I wanted to do with that, but of the hundreds of people in that film program, a tiny handful become famous Hollywood directors or cinematographers, or on that end of it, a lot of folks end up going on more the business side or the back end of the film industry. And I thought with that background, initially what I wanted to do was entertainment law. Thought it's a good undergraduate degree to have if you're going to go to law school and you want to break into entertainment law. Entertainment law is a very challenging industry to break into. I can tell you I'm currently the chair of the film and television section for the ABA Forum on Sports and Entertainment Industries. So we have a large student membership, all also trying to get into entertainment law. And you got to have a pretty sharp pedigree. Usually it's graduating from a T14 law school and working at an AmLaw 100 firm and just going that path, more of a challenge if you don't come from that background. After college. I think I took an LSAT free test or something to see where I'd score at, and I'm not a particularly good test taker, and that scared me off from law school for a couple of years. While I figured at some point I would work on improving that score and maybe go to law school in the future, I took a couple of years off, worked primarily in the real estate industry, and was actually out in Las Vegas bartending and selling real estate for what we call the good years up until 2007, when we all know what happened with the economy and the real estate market. And that's what sparked my interest in maybe going to law school and riding out the bad economy in that 2008 through 2011 rough patch. Whether that was a good idea or not, I would tell you coming out of law school at 2000 in 2011, it probably wasn't the best decision because I believe to date, and Chuck, you can fact check me on this, the law school class of 2011 was the largest graduating law school class in US history, as a lot of other people decided to ride out the bad economy in law school or business school or whatever it might be. I ended up going to law school in New York. I went to the City University of New York, also referred to as CUNY. I went to the old CUNY, not the new CUNY. The old CUNY was in a abandoned elementary school building right across from the Queens College campus out there in Flushing. I was constantly reminded it was a former elementary school when I would use the men's room and I would notice the urinals were very low on the floor for, I guess, for children. The new CUNY Law School is much nicer. They have a relatively recently constructed building in Long Island City, excellent subway access, and more modern structure. That was a few years after I left. My legal career after then is nothing spectacular. Before I broke into ADR, I worked in the transactional side of things, not as a litigator, for a company that acquired ground leases for cell phone towers and billboards. Not terribly exciting stuff. And then I also worked in property management in New York for a period of time. How did I get into ADR? And I'll try to make this quick a story as I can. Largely by accident, but I wasn't particularly satisfied with my legal career at the time, and I had been transferred by a company to the DC area and decided to leave that company and look for a new job. And I didn't, I had never done doc review or any of these types of things that attorneys do when they're between jobs to support themselves, but I knew it was something I could do hourly and make a little bit of money while I was looking for my next job. I wandered into the Robert Half staffing office in Washington, D.C., just with the intention of simply asking to get on a doc review assignment. I've heard it's not particularly challenging work, and they're always hiring people to do that kind of work. And the gentleman I sat down with at Robert Half that interviewed me said that he liked my personality. I don't know if he says that to everybody, but he said that I could get you on a mind-numbing doc review job, and you can do that for the next couple months while you look for your next job. But I think you'd make a good actual like a recruiter. Like you should work at Robert Half. You should place people in jobs and all that kind of stuff. And I said to myself, it's not necessarily what I aspired to do in life. And he said, "You're between jobs, right?" And I said, "Yeah." And he said, "One of the great things about being a recruiter is maybe you don't work here for the next 5, 10, 15, 20 years of your life. Maybe you don't even like recruiting. But you're going to be put in a position where you're going to see all sorts of jobs you might be interested in, and you're going to get first crack at those. So hire yourself out of the role," is what he basically said. Not officially, but unofficially. And the year and a half I worked at Robert Half was actually one of the most interesting years of my legal career because I learned just about everything there is to know about practice areas of law that I had never been exposed to, that I knew nothing about. But when I was put in a position that I had to find attorneys to match these positions, I made sure I learned everything about that particular area of law. And I used to joke I'd say that kind of training is good training to be a GC at a company because a general counsel at a company can't just be a transactional person, right? They can't just be a litigator. They can't just be a litigator in a certain field or do transactional work in a certain area, right? They have to understand the entire legal ecosystem. And that's what I learned. So fast forward, I wanted to move back home. I asked Robert Half to transfer me to the San Francisco office. They were happy to oblige. And I had a team of people that I was working with, and there was a young man on my team whose job was primarily to look through online job postings and newspapers and whatnot for open positions that I might be able to staff. And he came across a job for a legal receptionist or a receptionist position at a company called Judicate West, and he brought it to my attention. He said, Aaron, I don't know what Judicate West is. I don't know what they do, but it looks like they're looking for a receptionist. Do we staff receptionists? And I said, sure, I've got a whole bunch of receptionists that are looking for work. I'll reach out to them. So I basically just cold called Judicate West, introduced myself, said I heard you guys are looking for kind of a front desk receptionist type person. I have a number of people that are looking for work that have that kind of background. The woman that I spoke with was Nicole, who's their director of operations, still is. And she was very nice and pleasant on the phone. And she basically said that for a lower level position like that, they don't really pay staffing agencies, right, to fill those types of jobs. But she would keep me in mind if something came up that she could use her help on. And I initially took that kind of as a very polite blow off. She's not going to keep my information or call me or anything like that. But so it goes. Anyways, a couple of months later, I got a call and they were looking to staff a regional director for their Northern California offices. They had just opened a San Francisco office and they were in the process of opening a Sacramento office. And they were looking for help finding this regional director, business development director up in Northern California to oversee operations up north. And they wanted to use my services to find the position. I found them a number of really good people. We got to the offer stage with a couple of folks, and there are funny stories about what happened with those individuals, but nobody actually ended up taking the job to fill the position. And I'm a contingent-based recruiter here. I only get paid when someone actually gets hired and takes the job and all that kind of stuff. And I had really gotten to know Nicole and some of the folks at Judicate West through this process because they were interviewing my folks and all that. And I thought it sounded like a pretty cool place to work in a really well-run company, which it is. And I eventually just said, part of my language, F it, I'll apply for the job. Hire yourself out, if you will, right? Now, I didn't, I brought this up with them at the time. I wasn't entirely new to the ADR world because I'm actually a second generation ADR professional. My mother was a mediator and an arbitrator for a very long time.
Huh?
She passed a couple of years ago, but she was most recently on the FINRA panel. But prior to that, she was doing community mediation with the San Francisco District Attorney's Office. Terrence Hallinan, who was the DA, I believe, in like the 90s, something like that, a long time ago, was running like this community justice clinic where kind of they would mediate low-level criminal offender cases and things like that to find out, like basically like a plea bargain, if you will. But they were using people from the community to be part of the program. And that's how she got her start. And then she really enjoyed kind of the mediation space, but wanted to get into more civil mediation and arbitration and all that. So she went to Harvard Law School for a couple of weeks and did that Getting the Yes program, right? Which is very famous over there. I remember she brought me back a sweatshirt from Harvard Law School, which I think I still have somewhere as a memento. And yes, I knew what mediation and arbitration were. I had heard of the American Arbitration Association and probably JAMS just in the many contracts I was reading when I was working for the company that was doing the ground lease acquisitions. Almost all of them had an arbitration provision. It was one of those two providers, but I was not familiar with Judicate West or Signature or ADR services are some of the smaller California ones. I wouldn't be familiar with them because most of my legal career was on the East Coast, and those were organizations that were regional providers in California. But I worked at Judicate West for a number of years. Var, Allen, Mark, Rosemary, all those folks, just absolute professionals. You really appreciate how none of them are attorneys, yet they built this business from the ground up, and they did it the right way. Um, in my opinion, by recruiting some of the best neutrals around. Enjoyed my time there, but I was really interested in arbitration, but specifically commercial arbitration. Judicate West is primarily mediation and primarily what I call consumer tort mediation, auto accidents, slip and fall, medical malpractice, employment cases, that kind of stuff, which is interesting. But I came from more of a business background, and I was interested really in getting involved with cases that are the quote unquote bet the farm type litigation when two big companies go at each other over a breach contract action. I knew Judicate West wasn't getting those cases because Judicate West, it wasn't written into a lot of arbitration provisions and contracts because they're not really a national provider, if you will. They're more local. Serena Lee, who you know from our CLE ADR group, previously held the position as the regional vice president in San Francisco's office for the commercial division. And she was in the process of taking the JAMS position in San Francisco. So the position was becoming available. And I essentially took her role in San Francisco. And that's how I ended up at AAA.
Now, what a fascinating background. Uh, your background bespeaks a particular aptitude for getting along with people.
Yeah.
And no doubt that's an important part of your job. But I wonder if maybe you could expand on that a little bit more. And so, in your current position with AAA in San Francisco, what is the area of your responsibility, and what are the key points of your day-to-day professional life?
So I can go over the regular things that I do, and I go to list down here: basic operational management, business development, panel recruitment, customer service. I do case manage some of our large complex cases, but not that many. And interfacing with our in-house legal team when things don't go right. And but really one of the things that I spend the most time doing, and this is related to business development, but it's also trying to ingrain myself as a thought leader somewhat in the ADR industry. I want to be the type of individual where attorneys come to me with questions and things like that, right? They feel they can do that. I teach anywhere from 30 to 40 CLEs a year. Some of them are webinars, some of them are in person at conferences and things like that. And this is all in addition to the podcast and all the other different things that I do. I'm council member for the American Bar Association section dispute resolution. I mentioned my involvement with the ABA's entertainment section. I am on the executive committee for ADR for the CLA litigation section with you, Chuck. Just lots of different outside organizations that I'm part of. And that takes up a lot of my time. I do traditional things too. I visit law firms and I lecture at law schools and those types of things. But every day in my job is completely different. I've never had 2 days in a row that were the same day, and I've never found myself sitting around with nothing to do. So that's what I really love about my job is it doesn't get boring.
One of the things I know that AAA has been particularly involved in is promoting the efficiency of arbitration, and that includes eliminating obstacles to a smooth resolution of a dispute by improving the quality of clause drafting and so forth. This is an area you've been involved in, and I wonder if you could just amplify a little bit about the work that you've done and where all of that is headed.
A number of years before I was hired at AAA, The regional vice president role was almost entirely business development and overseeing panel recruitment and adjustments to the panel, rotating people on and off, that kind of stuff. It what there the regional vice presidents didn't do much in the way of case management. So now when I say I do case management, I manage a handful of cases each year, and these are the biggest cases we have, claims in the hundreds of millions of dollars, sometimes billions of dollars. And I feel I really learn a lot about the arbitration process from working as a case manager. Is case management my main job? Absolutely not. We have hundreds of case managers and case administrators and people that work in that area at AAA. That's a whole separate division in operations. But I've learned over my time managing cases where the snags seem to happen in inefficiency. I'm very passionate about arbitration efficiency because arbitration only exists as a concept because it's supposed to be a faster, more cost-effective way at resolving disputes than traditional litigation. And I've got to tell you, Chuck, in recent years, and not just at AAA, but all providers and even ad hoc folks, that's starting to shift. Arbitration is starting to get really expensive, and parties are starting to notice. And some parties are starting to abandon arbitration altogether in contracts because they feel they'd rather take their chance in court than some long drawn out expensive arbitration process. So what I've learned during my time as a case manager is a lot of the problems with inefficiency start with a poorly drafted arbitration clause or an arbitration clause that contains a lot of things that aren't necessarily necessary for the type of dispute, but are going to add a lot of time to the dispute and make the dispute cost a lot more money. So what I always tell people, and this goes for whether you're drafting a AAA clause, a JAMS clause, or any other clause, there are 5 things that have to be in every provision. And these are the 5 things that are most commonly fought about. And these are the 5 items that, if one is missing, cause the most outside problems. So the first thing is the type of rules that you're going to use. And do not just say AAA rules or JAMS rules, right? You need to be specific about things. So at AAA, I want to know, is this the commercial rules? Is this the employment rules? Is this the consumer rules? You might think it might be pretty clear from the type of contract which set of rules we're talking about, but a lot of times things overlap, right, in different rule sets. So you want to be clear about the rules so there's not a fight over that. The next thing would be the number of arbitrators, right? Are we going to do a single arbitrator? Are we going to have a panel of 3 arbitrators? At AAA, we, based on the size of the claim, if it's silent on that, we have a rule that says whether it's going to be 1 or 3, but it's really best to explain it in the arbitration provision so there's no discussion there. Now, I might get in trouble for saying this, but I'm going to say it anyways. I am not a huge fan of 3 arbitrator arbitration panels. First of all, they cost 4 to 5 times more expensive on average than a single arbitrator. Why not 3 times more expensive? But when you work out how the extra hours that the chair usually ends up billing to supervise the wings and finding up work and all that kind of stuff, really is a lot more expensive than 3 times more expensive, depending on people's hourly rates and all that kind of stuff. Most disputes, a single arbitrator that is skilled in the subject matter area, fair and unbiased, and jointly selected by each side, assuming both sides support this individual, is going to do just fine. If you have a contract that is so complex, or you're dealing with a claim that is such a large amount of money, hundreds of millions of dollars, billions of dollars, something that could literally end your company, right? If it goes the wrong way, and you want to have 3 arbitrators, go for it. So that's the second thing, is the number of arbitrators, spell it out. Third thing, location, sometimes referred to as the seat of the evidentiary hearing. Even if it's not going to be in person, it's good to pick a seat. City and state, please pick 1 city and 1 state. I see too many contracts where they list multiple cities as options and multiple states as options, and that's just going to lead to a fight. If one company is in New York and one company is in California, they're both going to fight for their own region, right? You should have a choice of law provision in there according to California contract law, right? Especially if it's California contract, so people aren't guessing there, especially if you're dealing with parties in two different states, and not just substantive law, but also the procedural law. If you want the California Arbitration Act to govern the process, spell that out, right? If you want it just to follow the FAA procedures, spell that out. And then the last thing, which is oftentimes missing from a lot of arbitration provisions, is a prevailing party clause and what exactly the prevailing party is entitled to. So we're talking about attorney's fees, arbitration costs, those types of things. And you really want to be really specific about what you mean. Too many times I've seen a prevailing party clause where it says that the winning side is entitled to collect attorney's fees. And when the winning side is preparing their attorney fee application to send to the arbitrator to add to the final award, what do you think they put in there? Attorney's fees, the arbitrator deposits, the administrative fees charged by the ADR provider, all the hotel rooms for the evidentiary hearing, all the plane tickets, all the meals. Wait a sec. Did it say in the arbitration provision you're entitled to all that? I think it just said attorney's fees, right? So if you mean for somebody to get the whole shabam, right? You got to be really detailed in the provision and explain all that out. Because then if you don't explain it and one side thinks they're entitled to it, you're going to have both sides brief their positions. Folks might look at case law. Some states say yes, some states say no. Some states treat the winning party in arbitration like they would the winning party in court litigation. Some states don't. Some states codify this. Some states use case law, right? And it's just going to elongate the process and end up costing a lot more money. So I think the arbitration provision is really important because really a poorly drafted arbitration provision, as I say, is you're driving down the freeway and a little pebble hits your windshield, causes a little crack, right? You might not think anything about that little crack when it initially happens, but over the life cycle of that contract, that crack is going to start to get a lot bigger. Eventually, it's going to go across your entire windshield and the windshield's going to fail. That's what a poorly drafted arbitration provision is. You don't think about it initially when you sign that contract, but it could really bite you in the rear end in the end.
Let me shift gears to another topic I know that is at the forefront of your mind. We all are talking about artificial intelligence on a daily basis. And there have been those who have raised the specter that a computer is going to take over the role of judging and arbitrating, maybe even mediating, who knows? But short of those sort of extreme fears, there's a great role to be played by artificial intelligence, and you're involved in that. I'd be interested in having you share some of your personal experiences and some of your prognosis.
Yeah, 2 years ago, we got a new president and CEO, Bridget McCormick, former Chief Justice of the Michigan Supreme Court here at AAA. And Bridget's a real, I guess what I would say, AI futurist. She likes to joke that we're a 100-year-old startup and we're not just doing things the same way we always did at AAA. She's really shook things up with new things that we're introducing in the AI space. So a number of years, and over the last 2 years, we've come out with a number of tools here at AAA that work within AI. The first was Clause Builder AI, which you can visit at clausebuilder.ai, which was we had always had an online website where you could draft an arbitration provision by answering a series of questions and essentially copy and paste that into a contract. I think that's a great thing to have. I've used that website, originally called clausebuilder.org, for law school demonstrations and things like that when I teach arbitration clause drafting. But we wanted to upgrade it to more of an AI function where now, instead of going through a series of questions manually, I can just type in a prompt like I would into ChatGPT. I can say, draft and software as a sales agreement between two technology companies to be heard by a single arbitrator in San Francisco or something like that. And it'll literally take what I just wrote and spit it out like in the correct legalese. And then if I want to further refine it, it'll give me a couple of options to do. So I thought pretty cool technology. And then we've come out with a number of other tools after that. A big one was the AAA AI arbitrator search. In the old days, our arbitrator search technology relied on what's called keyword search technology. We've all entered a keyword in and into a database and it's looked for that word. But this is no longer a keyword search, it's what's called the semantic search. So I'll give you an example. The parties are using our search tool to find a good arbitrator for a construction defect case involving a stadium. Now, in the old days, if I was a construction defect arbitrator and I referred to stadiums as arenas, and I had a lot of experience with arenas, my resume would be completely missed because they're typing in the word stadium, and the system's not smart enough to know that arena and stadium often mean the same thing. Now, with the new semantic search in AI realizes that stadiums, arenas, coliseums, etc., mean the same thing, and that resume will get pulled. So it's a lot more accurate. We have a AAA AI rules chatbot where you can chat back and forth, as well as a AAA AI chat book where you can go over the process of an arbitration and kind of the various steps. This is particularly useful for pro se litigants that really don't understand how arbitration works. So it's basically instead of them just calling our customer service number or spending a lot of time with the case manager asking them questions about how things proceed, this basically can use AI to answer their questions. I don't know if you've had the pleasure of ever being an arbitrator on a case with a pro se claimant or respondent, but you have to walk a very fine line between, am I giving this pro se individual legal advice or am I just explaining what I'm looking for? And that's always something that's been very difficult for arbitrators working with pro se individuals. And then, of course, the most famous AI tool that we have that we debuted a few months ago would be the AAA AI arbitrator. Now, before people get up in arms and talk about this is going to get rid of human arbitrators and this and that, or it's just another AI thing that is taking over our lives, we beta tested it and we've released it for a very narrow type of case right now. We want to see how it does. These would be construction fast track cases. They tend to be construction defect cases with claim values usually under $100,000. And the reason we chose specifically these cases is because we already have a large data set on them. In a lot of the situations, the fact patterns tend to be similar. So it's easy to train the AI arbitrator on the specific caseload. And just really quickly, the way it works, it's quite simple. The parties submit their briefs. The claimant's going to submit their demand and their exhibits and supporting evidence, and then the respondent's going to submit an answer, supporting evidence. The AI arbitrator is going to summarize each side's argument and then send that argument back to the parties and say, hey, based on reading your claim and hey, based on reading your answer, did I summarize this correctly? And the parties will either say yes, no, or these are the areas where we think you didn't get it correct. And then you have the opportunity to correct the AI arbitrator. Then the AI arbitrator takes that, produces an actual award, and then that award is sent before the parties see it to a human arbitrator for review. And the human arbitrator is looking at, did the AI arbitrator hallucinate, like award a lot more money than the claim was seeking? Did it award money on causes of action that didn't exist in the complaint? Did it completely get the arbitration wrong? All this kind of stuff. And the human arbitrator then decides whether or not the award's ready to go out, and they have the authority to correct it. And ultimately, they're the ones that sign it and submit it. That human arbitrator will go through the same appointment process as they would in any other case. The parties know who the human arbitrator is. The human arbitrator has gone through the full disclosure process with the parties, all that kind of stuff, just to make sure everything's on the up and up. So that's how the AI arbitrator essentially works. And like I said, we've just debuted it and we're excited to see where it goes.
Aaron, you're a bit of a role model for younger lawyers who are interested in trying to break into the ADR field. You mentioned earlier the positions you hold with the American Bar Association and a variety of related, I'm going to call them extracurricular activities that get young lawyers out of the office and begin to raise their profile.
Yeah.
Share with us a little bit about your own personal experiences in this arena and what value you think it has had for you.
So I'm very sad to see that, I guess, enrollment in bar associations and professional organizations in general seems to be on the decline in the United States. And I don't know if that's because membership's expensive and law firms aren't paying for their associates to be members of these groups anymore. I don't know if people just simply don't have time to do it or what it is, but I find being connected to a professional organization is very important to my professional development. So what I tell people is everybody should be a member, if they can, of three bar associations. You should pick a local bar association, a state bar association, and then a national bar association. So for me, I'm very active with the Bar Association of San Francisco. That's my local bar association. I'm the vice chair of the litigation section. I have the pleasure of serving with some very prominent San Francisco attorneys that are doing great work on that. I'm a member of the California Lawyers Association. That's my state association with you, Chuck, right? And work that we do. And then the American Bar Association be my national organization. Specifically in ADR, if I could give a plug for the ABA dispute resolution section, I've learned more about what our industry does, trends in the industry, who's doing good work, potential new areas for mediation and arbitration, new technologies, whatnot, from being a member of all of those organizations than I would just by hearing through word of mouth, just me doing my own research on the side. And it also I really enjoy feeling like I'm truly part of an ADR community. It also gives me the opportunity to see what other ADR providers are doing. One of the really cool things I think, Chuck, about the CLA ADR section is we've got folks from AAA, folks from JAMS, folks from Signature, Judicate West, etc., ADR services. And I learned what other organizations are up to. So I really enjoy that. So I hope if you're a young attorney, or I shouldn't say young, a junior attorney, anybody can go to law school at any age. I went to law school a little later. And you're interested in ADR, your first step is joining one of these bar associations and specifically the ADR section within the group.
One of the things that you have done, and I guess I should say are doing, is using podcasting
Yeah.
as a way to contribute some substantive knowledge to the listening public, but as well, it has to have some impact in increasing your profile and visibility within the profession. Tell us a little bit about how you have used podcasting and what you think is its application.
Yeah, I got my start in podcasting with the ABA Dispute Resolution Section's podcast Resolutions. I was first introduced to it when a couple of years ago I was the educational programming officer for the section. And while my main job was producing webinars and things like that, I would sit in on the monthly podcast meetings and we would brainstorm ideas and whatnot on future podcast episodes. And then that evolved into me becoming actually the committee chair for the Resolutions podcast. And first of all, I'm going to give a lot of credit to my fellow committee members. When we meet every month and we brainstorm and bounce ideas off each other, that's the best way to come up with interesting topics. I had not had any podcasting experience prior to Resolutions. And as a podcast fan myself, I thought it was just people talking. And you hear about just interesting stories as they go along their conversation. But then I quickly realized that most podcasts, the successful ones, are highly scripted, and a lot of preparation goes into those podcasts. So I do spend a lot of time before I interview somebody for the podcast, coming up with a script, interesting questions to ask them, making sure I get that script to them plenty of time in advance, kind of like I sent you a little script of some questions you might want to ask me, just so it has a smoother flow to it, as opposed to what do you want to talk about? I don't know. What do you want to talk about? And podcasts I really enjoy because, as opposed to webinars, which usually have a date and a time and a place, although some webinars are in the library of webinars and you can go back and watch them after they've been recorded, a podcast is something that's really simple. You can listen to it at the gym. You can, when in the car at night. My wife is a big podcast fan. She uses them to fall asleep. She listens to a podcast, and they don't really have a shelf life unless you're talking about something that's super topical within the time frame. So people can come back to your podcasts and listen to them at their own leisure. It does increase my exposure and AAA's exposure through my work doing them because, yeah, they're on a lot of different platforms, Spotify, Apple Podcasts, Amazon Podcasts, whatnot. If you Google my name, a lot of the podcasts, they pop up pretty soon, pretty quickly at the top of the list. But I mainly do it because I love talking to people about interesting ADR topics, and I find more so than sometimes doing a webinar, that's the best way for me to connect with somebody that I'm interviewing. And a quick plug, I actually have a second podcast. I started a podcast for the ABA Science and Technology Law section called the SciTech Lawyer Perspective. We've had a couple episodes go out there, including my most recent one back in December with where I interviewed Bridget McCormick about the new AI arbitrator. So you can find that on Spotify or on the ABA SciTech section of the ABA website.
Aaron, my gray-haired contemporaries do think of you and your peers as the future of ADR work in California and the West. Maybe let's talk about the world writ large. But I would welcome your thoughts as a person who's making a huge mark at an early age in your life, relatively speaking. Talk about the future and what excites you about the prospects for your career going forward.
I'd say this. First of all, I wouldn't worry about AI taking away jobs necessarily from mediators and arbitrators. Bridget has this saying that AI is not going to replace neutrals, it's just going to replace neutrals that don't use it. And we have a number of AI tools that we provided our panelists, including ClearBrief, which is similar to a Lexis or a Westlaw, but it helps them do case research using AI, and it's what we call a closed source AI tool that only takes cases and information that's been programmed into it. It's not scraping the internet like ChatGPT might, which occasionally comes up with cases that don't exist. We've all heard about those stories. So I think AI is going to play a big role in neutrals work going forward. I think there are some exciting tools that are on the horizon that have to do with predicting outcomes of cases and also helping parties settle in mediations, giving them a good idea of what their case is worth. There have always been verdict search tools through Lexis and Westlaw, whatnot, where parties can say, I've got a similar case to this going on. I want to see what a jury decided, what a jury awarded, or what an arbitrator awarded if the award was made public, or what the settlement was if it settled through mediation. I don't know if you do this, but the California Daily Journal, I like to when I got the paper edition, I'd flip to the back pages where they would go over the settlements and they would put the name of the mediator who worked on the case. It's a great way for me to see who's doing good work. But I was always curious. I would list the names of the attorneys, brief synopsis of what type of case it was, and who the mediator was, and what it settled out. I thought that was great. So I think there's going to be a lot of tools in the settlement space, certainly. And I think there's going to be new people coming into the field. I think ADR has fallen under a stereotype that this is a second, third, fourth career for a lot of folks. A lot of people were litigators for 30 or 40 years and they've retired from litigation and now they're doing this type of work. So that's one reason why I think a lot of younger attorneys don't really see a space for themselves at the current moment doing this work. But I always tell younger, more attorneys that are more junior in their careers, if you're interested, for example, in being a mediator, see if you can be a judge pro tem and mediate a couple of cases for free through the settlement court. A, it's relatively low stakes. No one's actually paying you for your time, so they're not going to be necessarily upset at you if you didn't settle the case. But B, some of these at bats you might be getting doing some of the free or the pro bono settlement court work will
Mhm.
actually let you know if this is the right field for you. There's an awful lot of people, for example, that think they'd make a great mediator, and then they try to mediate a couple of cases and they don't actually settle anything. And then maybe they discover that they're not quite the mediator they thought they'd be. You shouldn't let that discourage you. Mediation's a muscle. You have to work it, and you'll get better as you go along. But what better place to start in some of these county court panels and whatnot? With arbitration, if you're interested in a career as an arbitrator, you really need some litigation experience, is what I tell people. I think mediation is an art. I think there are just some people that are put on this planet that are born to resolve people's disputes. They're natural peacemakers. But arbitration is a lot more specialized than that. They want you to understand the subject matter area of the type of dispute you're arbitrating, and they want to know that you've been through the entire litigation process and that you understand motion practice and resolving discovery disputes, and you can correctly analyze a case and apply case law and things like that. I think somebody would have a very hard time doing that if they didn't come from litigation background. Now, that's not to say that, at least at AAA, you can't be a subject matter expert arbitrator. One thing that a lot of people don't know is we do have people here at AAA that are on the arbitration panelists that don't have law degrees, that have never been attorneys. They're not retired judges. They were an engineer for 30 years, right? And they do construction defect cases that focus on engineering failures. Who knows more about engineering failures than an engineer, right? Same thing too if you're doing an accounting malpractice case and your background's not as an attorney, but you're a licensed CPA, right? You probably know a lot about accounting. You're a CPA, right? Maybe you've served as an expert witness in cases and other accounting malpractice cases or something like that. So get some litigation experience. On the mediation side, if you're a junior attorney, I would say you really need to find a way to advance from just being the junior associate that drafts the mediation brief and then disappears into the background. You want to see if the partner on the case will actually maybe take you to a couple mediations, maybe even let you become a part of the mediation process, as opposed to just drafting the brief for the mediator. And on the arbitration side, see if you can second chair in arbitration. And if you do a good job as a second chair, maybe they let you move up to first chair and start handling your own arbitrations, maybe starting with smaller cases. So I do think there's a lot of space for more junior attorneys to get into the mediation arbitration space before they're retired from whatever it is that they were doing or retired from firm life. But they have to look for those opportunities. And I'll say the same thing too with attorneys that reach out to me that are thinking of building an ADR practice. I think one of the toughest things that I see are too many attorneys that are, Aaron, I've been a litigator for 40 years. Last week, I ripped my nameplate off the firm wall, and now I want to do mediation, or now I want to do arbitration. Let's get started. And I have to tell them, I'd say, like, really, it's not that easy. Unless you're a super popular retired state or federal judge that's coming off the bench, if you're coming just as a subject matter expert or an attorney arbitrator or mediator background, it takes a number of years to really build up a practice. And what I recommend for those folks is do the pro bono work, start getting involved with ADR organizations, and set a practice goal for yourself. Say to yourself, listen, I want to become a full-time mediator at some point. I'm 55 years old. I want to retire at 65 from firm life. At 55, next year, set a goal for yourself and say 10% of my firm revenue that I bring in, I want to be from mediation. And maybe in 2 years, it could be 20%, or 3 years at 30%, right? You're slowly shifting into a career in ADR as opposed to slamming on the brakes on your legal career and then announcing this is what I'm going to do. Because people in the field might know you as a great attorney, a brilliant attorney, but they don't know you as a great mediator. They don't know you as a great arbitrator. And it's going to take a little bit of warming up for them to think of you in that space.
This is sage advice from a guy who's been around the barn several times. Aaron, thank you for taking your time to be with us and share these thoughts. We've covered a broad range of topics here today. A listener could listen to any segment of these and walk away a lot brighter and a lot better informed. And I think we owe you a great round of applause for sharing your experiences and teaching us today. Aaron Gothelf with the American Arbitration Association, thank you and best wishes. California Conversations is much better now for having had this session with you, and we wish you the very best.
Thanks for having me, Chuck. I had a great time today.